I'm Tanya Iser, investigative reporter here at Channel 8. We are here for day 6 of the Amber Guyger trial. We're expecting the proceedings to kick off around 9 a.m. The thought is going to be that they're probably going to have more hearings on getting additional expert witnesses in. We don't know exactly who those witnesses are. I'm waiting for Rebecca Lopez to call in so we can talk some more about yesterday's proceedings. As we all saw yesterday, Amber Guyger testified. She took the stand as her attorneys had promised she would. They had told jurors that she would take the stand, and her testimony was emotional, and she cried at various points. Her story was that there we see the judge in the courtroom. She's looking at some documents. And now that we're hearing sound in that courtroom, so I'm guessing that the judge is probably going to kick off here pretty soon. The judge has really run a tight ship, a very tight ship in this courtroom. She's been very prompt, and I still think one of the most fascinating things about this judge is just how I've certainly been in a lot of courtrooms, but she has been very clear about cell phones and laptops and every, she does not want any distractions to this jury. She wants them to, make their decision without any interference. But back to Amber Guyger's testimony, she testified she had worked that day. It was a fairly lengthy day. She had gotten off work, and she went back to her apartment. Okay, we're starting to hear some sound. I really think we're about to get started here. Be interesting to see what we're going to hear from first. I still kind of think, based on what we saw yesterday afternoon, that we're going to have some hearings on additional expert witnesses. Late in the afternoon, we had lengthy hearings for witnesses, expert witnesses that the defense wanted to get in front. Oh, sorry, we got a dog here in the newsroom. It's okay. A little excitement. I don't know if y'all heard that, but it's a Saturday, so quite a few of us here at work. So the one witness that that the judge ruled could not take the stand was a firearms expert who would have testified to different probable angles of that bullet trajectory, and the judge basically ruled that the testimony that we had heard earlier from Ranger Adcock about that bullet's trajectory was enough, and there may be a better legal way to say it, but basically said that she would not allow that testimony. But clearly the defense was trying to present testimony that it would have been more in keeping with what Amber Guyger was claiming about where she was and where Botham Jean was when she fired that gun. The prosecution has been, their contention has been that he was sitting on the couch, he was eating a bowl of ice cream, and that he was likely in a crouched position, well, not crouched, cowering position when he was shot. The defense has been trying to contend, and based on what Amber Guyger testified to yesterday, their contention is that he was coming at that door yelling, "Hey, hey," and that she said, "Let me see your hands, let me see your hands," and that he kept coming. Probably, no matter what you believe, they were both, he was obviously confused because she had come into his apartment, and so that all plays into it. We also heard again from Ranger Armstrong. The defense was still trying to get Ranger David Armstrong's testimony before the jury. He is the lead investigator in this case. I've been covering crime and policing for a long time. 20-something years, and I've never seen a lead investigator say the kinds of things he said. He said that he believed, and this was outside the presence of the jury, he believed that Amber Guyger's actions were reasonable, and I'm going to, okay, here we go.
Before we begin, are you ready, Ms. T? This one.
Yes, ma'am.
All right, before we begin, I believe Mr. Mullen has some things that he would like to add to the record.
Very briefly, Your Honor. I want to move to admit Defendants Exhibit 93, which is just a paper copy. The defendants renewed objections regarding the exclusion of parts of Ranger Armstrong's testimony. I want to just make the record clear, although you did reference it yesterday, Your Honor, I want to make the record clear that this applies both to Ranger Armstrong's testimony and Mr. Haig's, Michael Haig's excluded testimony. So Defendants 93 for record purposes only. I believe that Mr. Hermans didn't have an objection.
No. All right, they are admitted for record purposes.
And also, Your Honor, in addition to the objections that are in Defendants 93, I also want to renew the objections to the exclusion of Mr. Haig's testimony and the excluded parts of Ranger Armstrong's testimony under the compulsory process clause of the Sixth Amendment and the due process clause of the 14th Amendment. Just ask the court for a ruling on that.
Oh.
Thank you.
Okay. And before we bring the jury in, I think, Mr. Rogers, you wanted to qualify your other expert.
Yes, Your Honor. Craig Miller.
Or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please make yourself comfortable.
Judge, I'd offer Defendants Exhibit 94, which is the CV of Mr. Miller.
Thank you.
For record purposes.
You don't have any objections, do you, Mr. Hermes?
No, Your Honor.
It's admitted for record purposes.
And Judge, I don't think our fight, I don't want to speak for Mr. Hermes, but our fight's going to be over qualifications in general, but I'm just going to point out a few things. You have his CV, and then get straight to his opinions. That's okay.
That's fine.
Please introduce yourself and spell your first and last name.
My name's Craig Miller, C-R-A-I-G-M-I-L-L-E-R.
And how are you employed?
I'm currently retired for my second time.
And what's your current profession?
I work as a testifying expert witness in police use of force civil rights cases, as well as a security consulting firm that I own doing school vulnerability assessments.
And the judge has your CV, but I just wanted to point out a few things. You worked for the Dallas Police Department for how long?
Nearly 30 years.
And you achieved up to what rank?
I came through the ranks. I was a deputy chief when I retired in 2011 over the Crimes Against Persons Division, which oversees the 180 criminal investigators who cover homicides, sex assaults, robberies, and the CSI function for the 1.3 million people in Dallas.
And were you also in different supervisory roles for lieutenant with the Crimes Against Persons Division?
Yes, prior to being appointed as a deputy chief, I was the homicide commander for the Dallas Police Department from 2007 to 2010, during which time I oversaw 750 murder investigations, as well as 75 officer-involved shootings that I was at the scene of, where more than 100 officers discharged their weapon.
And after leaving the Dallas Police Department, what was your position?
I retired to take the job as the chief of police for the Dallas Independent School District Police Department, and I retired from that position this past March 2019, after my 8th school year.
And have you testified in federal court as a use of force or use of deadly force or police practices expert?
I testified in federal court this summer in Austin and in Dallas. Yes, sir.
And have you been designated as an expert in state court as well?
I have. Yes, sir.
Mr. Miller, have you also been through the Force Science certification course?
I did. In 2015, I attended the 40-hour Force Science Institute training course.
And can you tell the judge what that is?
Yes, sir. Force Science is a research-based scientific institute that deals with determining human behavior regarding deadly force confrontations involving police officers and the science behind the actions that the officers took that's research-based.
And did I ask you to apply all your experience, your training in looking at the case involving Mr. Jean and Amber Guyger that occurred on September 6, 2018 and make some conclusions?
Yes, sir, you did.
Can you tell the judge your opinions as to the reasonableness of Amber Guyger's actions once she stepped into apartment 1478 on September 6, 2018?
Yes, I used the same methodology when I approached these as I did when I was with the Dallas Police Department, as well as I teach officer-involved shooting class. I've taught in 4 different states this year. And when I look at that, I try to look at the totality of the situation. Obviously, I use, because I'm from Homicide, I use a victimology type approach, which I want to go dealing with both the suspect and the victim in the case, or the person, the witness, and the victim in the case. I want to know what was going on with them in those moments, and including days up to the incident. I certainly consider that information because that's a part of the investigation that I look at. But in conducting a criminal investigation, I really try to focus on that time and that moment in time when the actual force was used. So in this case, I really focused my emphasis on that time in the doorway. I considered all the evidence that you provided to me leading up to that point. But it's that moment in time when she's at the threshold of the doorway that I'm most focused on with regards to my opinions in this case. And in using that, I tried to use the principles that I've learned as well as the principles that I teach. And that deals with the first thing that I think you have to look at is something that's called in science, it's called inattentional blindness. Inattentional blindness, which is the tendency of the human brain to filter out visual images that are not relevant to the primary target. And I think in police work this is really important, but it's also inattentional blindness is something that's consistent with people. It's not specific just to police officers. And so in looking at that, this is why people want to know, well, how did the police officer miss an item? How did they not see this? Why did they not see that? And it is because their attention is so focused on that object that they're looking at. So I look at that in conjunction with a process that police officers go through. They must observe they must orient, they must decide, and then they must act. This act is a point I call the go, no-go point. And that go, no-go point is when they elect to use force against that person that they feel the force is necessary to be used again. And so I try to use that formula as my basis for why the shooting took place, and then I look at that information.
And were there other dynamics that are occurring in the shooting that you look at that you've seen in your 750 plus homicides and 75 plus officer-involved shootings, and your force science and your training and experience?
I think the thing that I really try to look at is that it's really simpler than it comes out to be, and that is the timing in conjunction with the movement. In this case, we know that based upon the testimony that I've seen, that Ms. Geiger places herself at the door with her left arm extended, with basically holding the left door open, that her left arm used to hold that door open, and then she is the time that she shoots the bullet in conjunction with the movement of Mr. Jean is what I try to focus on. And in doing that, I see that she is moving against that door with her arm extended. And I think it's important to note that in my experience as a police officer, 37 years, that when myself as well as other officers that I see at the pistol range and I see in qualifications, both in the school district and well within Dallas Police Department, that the first shot where there's no recoil is generally speaking the most accurate shot that a police officer will shoot. It's after that the recoil starts, when I see that a little bit of wavering with regards to the accuracy of the officers. So I try to keep that in mind when I'm looking at this. And then I think about the movement of Mr. Jean in this case and where he was. And I've heard the testimony, and I'm not going to get into the distances. I want to just talk about the fact that I think it's logical that if a person were in their apartment and someone opened their door, that they would want to know who that person was. And if Mr. Jean was able to determine that Ms. Geiger was extending a gun, pointing at him, I think it's logical that he would duck. Duck and cover is a very common thing that I think every person does when faced with a situation. And it's my opinion in this case that that's what took place.
And did you form an opinion as to whether the defendant, Amber Guyger, her use of deadly force was reasonable on September 6, 2018?
Yes, sir. I think based upon the facts, the totality of the facts that were involved, when you look at the unintentional blindness and what she was looking at, and you look at that loop that the officers' minds are going through with regards to that, and then the time that's available, because you have to realize that a person can pull their hand up and move their hand or their forearm up to a 9-degree angle in 12/100ths of a second. That's research-based empirical data. They can then lower their arm in 1800ths of a second. So this is going on faster, and all this is going on in their loop, in their brain. And it's my opinion that in this case, that Ms. Geiger, thinking she was in her own apartment, fired a shot at a person that she felt was a threat to her, and that was reasonable.
With regard to your opinion that it's consistent that someone would duck when faced with a firearm, and the angle of the shot the wound pattern we see in this case, is it consistent with your training and your experience and the research that you've seen that the position of the body when she makes the decision to fire the bullet versus the position of the body when the bullet strikes the body?
Yeah, I've been to hundreds of murders, and I've seen bodies fall in directions that I didn't think that they were capable of getting to. But in this case, I think it's very reasonable that when the duck and cover takes place regarding Mr. Jean, that in conjunction with the movement of Ms. Geiger against the door with her arm extended, that the path of the bullet would quite likely go that direction.
I'll pass the witness.
Good morning, sir. First and foremost, can you tell me what is your definition of reasonable belief?
Well, the Supreme Court says there is no definite answer to what is reasonable belief or reasonable use of force. In my mind, it is that definition of what a reasonable police officer would do when faced with that same set of circumstances in a tense, uncertain, rapidly evolving situation.
Right. And so, and I've read a lot of your transcripts and a lot of your expert opinions, And that is very consistent with your approach in the past, that you take your position or your basis of expertise when you are judging a case is based on a reasonable police officer standard in the circumstances.
That is correct.
And you rely, and then you also noted that was from the Supreme Court. You're referring to a case called Graham v. Connor, correct?
I am, yes, sir.
And that is specifically the marker by which you apply use of force situations and reasonableness in every one of the opinions that I've read that you've offered to a court before.
Yes, sir. That is the standard for law enforcement.
And that's the standard that you're using today, in your opinion, correct?
Yes, sir.
Okay. All right, so let me just do this. You want to testify about two things. Mr. Rogers went through the methodology that's going to be the basis of your opinion, or the background of it, but again, you want to testify as to two opinions. Number one, that you believe, that Craig Miller believes that Amber Guyger was reasonable in her decision to use deadly force.
That's correct.
Okay. And the other opinion that you want to offer is that you believe, Craig Miller believes, that Amber Guyger believed that she had to use deadly force.
Well, in assessing officer-involved shootings, I obviously am not Amber Guyger, and I can't put myself in her position. The actions of Amber Guyger are consistent with what I actually saw in working 75 officer-involved shootings involving more than 100 officers, as well as my training around the country. The force that she used when faced with the situation she was faced with was appropriate.
Okay, well, because Mr. Miller, you said on direct that your opinion was that I feel Miss Geiger felt that she was in her apartment and shot when she reasonably felt she was in fear. Is that your opinion?
Yes, sir.
So your second opinion then is going to be that you believe that Miss Geiger believed that deadly force was immediately necessary.
That's correct.
Okay, so that's going to be the two opinions that you want to offer the jury. That it is your opinion that deadly force was reasonable, and it is your belief that she believes that deadly force was immediately necessary.
Well, those are two of the things, but I'd also like to talk about the inattentional blindness and what that means, because I think that's important for the jury to understand what police officers as well as regular citizens are faced with and why they're inattentionally blind to things other than what they're focused on. So I think that's important for the jury to know.
And that was but that's one of the bases of your opinion, correct, is the reasonableness.
Yes, sir.
All right, and for inattentional blindness, you said that these are principles that you have learned. What exactly are you basing? What is the basis of your understanding of inattentional blindness specifically?
It is the tendency.
I'm sorry, I wasn't clear. What information source are you relying upon as your educational background when it comes to that particular word?
Well, the Force Science Institute, and then the many articles that I've read on that with regards to the cases that I'm currently retained on and the cases that I've been retained on in the past 7 years.
Okay, what articles specifically?
One I have in front of me talks about, it's a Force Science article titled The New Invisible Gorilla Study Aids to Proof of Inattentional Blindness. That's the one that I have before me today. I've read hundreds of articles on this, but I don't have them with me, and I can't recall the exact names of those articles or when they were published, Mr. Hermes.
So your reference for today, although I don't doubt that you've read other stuff before.
Yes, sir.
I mean, obviously, I can't voir dire you on stuff that you can't provide to me as the basis of your knowledge. So I don't know whether or not in these other articles they're legit or they're bogus. I don't know if they were peer reviewed. You don't know any of this stuff to confirm whether or not the information is accurate.
I'm sorry, sir. I would probably disagree with that because I believe that the basis of Force Science is that things are empirically peer reviewed, and Force Science talks extensively about inattentional blindness.
Sir, I think you will have to agree with me on this. Force Science is not without its detractors and critics. Forced science has been widely criticized by a number of people for its forensic and foundational basis. It is not accepted gospel. You have to agree with that.
No, sir, I wouldn't agree with that, because I believe that literally every single year, hundreds of police officers attend forced science training. I believe that your people at the Dallas County District Attorney's Office, people in the Public Integrity Unit have attended the forced science training.
Absolutely, sir. I'm not saying that all information from a variety of sources is good to have, but you're suggesting that forced science it is without detractors. And, for example, have you ever heard of Lisa Fournier?
No, sir, but I agree with what you're saying, Mr. Hermes, that there are detractors to forced science. I'm not going to disagree with that point at all, but inattentional blindness is not just a forced science analysis. Inattentional blindness is something that is scientific in nature for not just police officers, but every person in this room, every person alive has experienced in some way, shape, or form inattentional blindness.
Well, but that's going to be my second point. But before I got to that, I just wanted to ask you what your basis of knowledge was, and what you've offered me right now is one article that was in a magazine. Is that right?
It will be for today, yes, sir.
Okay. And can you tell me whether or not that article has been peer reviewed? Can you tell me what the research, what the research criteria was, the number of people who were involved in that particular study? Can you give me any kind of indicia of reliability and veracity for what it is that you're reading?
No, sir, I cannot.
Also, have you been the lead investigator in an officer-involved shooting?
Well, when I was in the crimes against person and I was the homicide lieutenant, we did it different than they do it today. We obviously always had a lead investigator who would be assigned in the case, but I was actively involved in the investigations and the interviews of the officers. So when you ask me have I been the lead investigator, no. Was I present at the scene? Yes, sir. Was I involved in the interviews with the officers? Yes, sir. Was I at that point involved?
I was just asking if you were the lead investigator in an officer-involved shooting.
Yes, sir.
Okay, is the answer no?
It is correct.
Okay. Then I wanted to also ask you, when it comes to this...
Or you have not been the lead investigator?
No, ma'am. When I was in Capers and SIU, and I was in charge of SIU.
You supervised other officers that were the lead investigators?
That's true, but we did it a little bit differently back then, where there was, like Detective Ibarra, who's been here, would have been the lead detective. When we went to the scene, at that time we did a walkthrough in the field. I would many times lead that walkthrough in the field. When we came back to the office, and we would sit down with the officers and their lawyers, and they would be preparing their statements. Many times I was involved in the questioning of the officers. And so whether I was the lead detective, I was actively involved in the investigation and not on the peripheral watching in, just approving things.
I'm sorry, Mr. Hermes.
No problem, Judge. I want to go back, though, to at least the one issue that I was talking about, Lisa Fournier, Fournier. Are you aware that, at least at the time of this quote, that she was an editor for the American Journal of Psychology and a professor at Washington State University? Have you ever heard of her, sir?
No, sir, I have not.
And concerning her opinion of the forced science structure and classes, she indicated that it was pseudoscience and lacked basic elements of legitimate research, such as control groups, and drew conclusions that were unsupported by data. So that is a contrary view, would you at least agree, of at least one aspect of your expertise?
Yes, sir.
Your opinion of forced science.
I would agree with it.
Okay. So when it comes to inattentional blindness, and then I want to also cover this too, we're going to assume for the purposes that it does exist. You're not going to testify that it exists in every case, is that right?
No, sir.
Okay, so in any given case, including in this particular case, whether or not there was inattentional blindness, you don't know for sure.
No, sir. In my experience with police shootings, having been there with the officers in the field, I think their memory recall and how even officers standing beside one another, where one officer would draw their gun and shoot a suspect and another officer never draw their gun, and then you say, what did you see versus what you saw? I find that consistent, that police officers don't see things the same way. And so I see that that's the norm, that police officers' memory and recall, when faced with stressful situations, act the way they do.
But what I'm talking about is inattentional blindness. Isn't it true that that will vary on a very individual basis?
That is correct.
And you don't know what degree Miss Geiger, if any, had any inattentional blindness.
No, I'm not Ms. Geiger, and I cannot speak for her. I can speak to how my experience with police officers was and inform the jury that it is a real phenomenon, in my opinion.
Right, but again, you would have to say that that occurs. Some, all are to no effect.
Yes, sir.
It varies.
Correct.
So it would be pure speculation based on what you may have experienced or what other people may have experienced, and how that might apply in this case.
I don't think a person that's been to as many police shootings as I've been to and been to as many homicides as I've been to would call it speculation. It's not just something that I've read in a book and that I've researched. I've actually seen it and experienced it, so I think it is much more common perhaps than you might suggest it is, Mr. Hermes.
Sir, I'm not making a comment on whether or not it's common or not. What I'm saying is going to be pure speculation on your part to gauge whether or not Ms. Geiger had any attentional blindness, or to what extent.
That is correct.
Okay, that's the point I'm making. Who can testify and who can impart any kind of degree of inattentional blindness that Ms. Geiger would have experienced?
Ms. Geiger.
And you know Ms. Geiger has testified.
Yes, sir.
Okay. So again, just to be clear, you want to offer testimony concerning the reasonableness, that it's your opinion that the shooting was reasonable, and it's your opinion that Ms. Geiger believed the shooting was reasonable. Oh, and yeah, and then you also, you had offered some evidence, or you wanted to give an opinion that Botham Jean was ducking at the time of the shooting.
That is my opinion, yes, sir.
Okay. What are you basing that opinion on? Because you heard Ms. Geiger's testimony.
Ms. Geiger, when faced with inattentional blindness, is focused on an object that she sees in the background, that she sees shuffling, and she's focused on hands, because hands are what we know as police officers can hurt us. I feel it's logical that Mr. Jean, or in this case, or a person, when someone was pointing a gun at them, would duck and cover. I feel that's logical.
So you've seen people who have been shot before many times straight in the chest, correct?
I have.
In the head?
Yes, sir.
In the back?
Yes, sir.
These are people who were presented with firearms, or firearms were presented against them.
Yes, sir.
They didn't duck.
I would disagree with that. I have seen people duck. As a police officer, when I've been shot at, I've ducked.
There are circumstances, Mr. Miller, of course, where people have ducked. But those circumstances, like everything else, the way in which a person is shot, they vary on a case-by-case basis.
Absolutely.
All right, and so, again, when it comes to ducking, that is a guess that you are making based on something that might have happened, in your opinion, that would be logical.
That it's a guess, yes, sir. There's no one will know that. That is consistent for me in my looking and reviewing this case as to the path of the bullet.
Sir, you don't know what the path of the bullet is. The medical examiner can testify. You weren't there for the autopsy, were you?
No, sir.
All right, Your Honor, that's all I have. I pass the witness.
Did you have more questions, Mr. Armstrong?
Oh, Your Honor, I did have one other question.
Go ahead.
Mr. Miller, I was also looking at some of your previous testimony. You told the judge that you had testified in federal court before, is that correct?
This summer I testified in Judge Sparks' court and I testified in Judge Lynn's court.
Right, and so you remember testifying in Austin in 2015, is that correct? in Orr v. Copeland?
I did not testify. I wrote a report.
Okay, do you remember at a pretrial hearing concerning what you were going to be allowed to testify to, the judge forbade you to testify as to any legal conclusions, including whether the defendant's use of force was reasonable?
I'm sorry, sir, but I wasn't at that pretrial hearing, so I don't know what all the city attorneys in Austin argued or were presented with.
Do you agree, or do you have any reason to doubt that the judge in the order was not going to let you testify as to what your opinion was on reasonableness?
I just don't know that, sir.
That's all I have.
This summer, did you testify in Judge Lynn's court?
I did, yes, sir.
Or were you allowed to testify as to the reasonableness of the officer's actions in a deadly force?
I absolutely was, yes, sir.
And in Judge Sparks' court in Austin?
Yes, sir, I was allowed to testify to the reasonableness.
With regard to inattentional blindness, you don't have every study that discusses that. There's probably thousands, but is that a concept that is widely accepted in your field?
Yes, sir, it is.
And with regard to the rest of the opinions that the basis of your opinions, are those all that widely accepted in your field of use of force applications?
Yes, they are, and I teach them as well in my class.
And with regard to the position of the body, is it consistent with the studies and your experience that an officer firing the weapon can see the suspect or the person they're firing at in one position, and by the time the decision is made to fire, by the time the trigger is pulled, the body can change in milliseconds?
Yes, sir. Scientific experiments have shown that a police officer is capable of firing 4 bullets in 1 second. There's a reason why I think sometimes across the country people feel like officers shoot people in the back when in fact they were facing them. It takes the average police officer more than a half a second to be able for their brain to tell their finger to disengage, to stop the shooting action, which is as a person turns, they could still shoot them in the back. That's scientific data.
So that's your application of that data to consistent with your opinion that Mr. John could have been going from an upright position to ducking during the processing of the decision to shoot?
Yes, sir. Absolutely.
That's it, Your Honor.
Mr. Miller, I'm just going to be very brief because that was also, you just talked about timing again. You understand the 0.56 seconds, you understand the study that is based on, it's called the Tempe study?
Yes, sir.
You understand that was also in a magazine and was not peer reviewed and is widely criticized and disputed?
Yes, sir, and I also realized it was in a sterile environment as opposed to a real life situation where people are under stress.
Exactly. It's just, its reliability is in doubt. Although the Tempe study is certainly something that is worthy of reading, it is not in fact accepted science throughout the entire scientific community. Agree?
Yes, sir.
Nothing further.
Well, I just have some questions because I'm curious.
Yes, ma'am.
Your inattentional blindness, you said that generally or oftentimes some officers experience it and that they are focused, their focus is centered on the suspect. Is that correct?
It's the tendency of the human brain to filter visual images that are irrelevant to their primary target that they're focused on.
And one of the other things you also mentioned is that some officers can observe something and never draw their weapons, and others can observe the same thing and do in fact draw their weapon.
And shoot their weapon. Yes, ma'am.
And shoot their weapon. So I'm just curious, when or if someone is experiencing inattentional blindness, what of the suspect are they focusing on?
Generally speaking, it's going to be that person's hands, or if there's a weapon. If they have a knife in their hand, they're going to notice the knife. If they see a gun in a person's hands, they're going to notice the gun. But they're going to notice that part of that person they think can hurt them the most.
And how do you know that is the center of their focus?
Well, from my experience in the shootings that I've been present at, that was their focus. And my research in reading articles on that's the focus in my training at the Force Science course.
So is there some scientific data that tells us what portion the shooter was focused on? Because I'm just curious, just for my knowledge, if you are experiencing an inattentional blindness, is it the movement of the person, or is it in fact their hands?
Well, they're really the same, ma'am, because the person is moving and their hands can be moving. Obviously, if I'm sitting here in this chair and my hands aren't moving, it's obvious. You know, you're gonna be looking for me to come up like this. If it's in the scene, if it's dark, I'm going to be looking for something, and light's going to affect this as well. But I'm going to be focused on the part of that person, witness that I think could cause me as a police officer the most amount of harm.
Is that generally what officers experience, that their inattentional blindness goes directly to the hands? Is that always or generally the case?
Well, I think really I'd like to describe it as more, it's the things that we kind of Monday morning quarterback in. Well, why didn't they see this? Or why didn't they see this? Or how come they could have missed this? In my mind, it really goes more to that whether it's specifically the hands or the movement of an object in the background that they're focused on, in my mind, in my experience, it's these ancillary things that are out here, that are out here that they're not seeing, and it's this object that they're focused on that they're seeing.
The other thing that I'm curious about is the information that you have imparted to us. The officers observe, orient, and act, and decide go or no go. Have you conducted similar studies with officers who did not shoot, or are these limited to officers who actually fired the weapon?
Well, I can speak probably firsthand from that, because as a police officer, I've been in many situations where I could have shot and I didn't shoot.
I know, but I'm talking about all the training and experience that you have. Is it equally balanced with decisions to not shoot that were made?
Yes, ma'am.
Or are we focused solely on officer-involved shootings?
No. Well, I do focus on officer-involved shootings, but are you talking about homicides? Or
you talked a lot about officer-involved shootings, so I guess the crux of what I'm trying to find out is there any information out there on the countless times when officers do not shoot? Or do we just look at when they have shot?
No, ma'am. I think that we have to look at the totality. I agree with you completely.
Are there any studies that we can look at to see, even when they did not shoot, was there an inattentional blindness going on?
I think probably embedded in all of these studies, when you look at the empirical data, that there are officers that didn't respond as quickly, or in many instances didn't shoot. So that is a part of the data, but don't really have that with me.
Well, I don't pretend to be an expert in this area, but just in trying to read up on this, I've been trying to look for other studies, just wondering, and I thought you might know.
No, ma'am.
I'm just wondering. So let me just be clear. You believe that you have the expertise, training, and experience to discuss what an officer's focus might be on at the moment in time when they make the decision after having observed, oriented, and decided to shoot or not shoot.
Yes, ma'am.
And you can describe generally that some officers may have an inattentional blindness.
Correct.
But you don't know whether or not Ms. Geiger experienced that, and nor am I going to allow questioning in that area if we go forward with this. But
Yes.
you can't say with certainty what her experience was, because you did not live her experience.
Exactly.
And as you testified, there is no reasonableness. So you don't know, well, stop. Let me stop. Are you both concluded with your questioning?
I am, Your Honor.
Yes, ma'am.
Are there any objections to Mr. Miller's testimony?
Judge, I do object. First and foremost, I think Mr. Miller has applied the wrong standard. He has applied the Grant v. Connor standard, which is the standard for civil rights actions under 1983 in federal courts for money. It is not the standard in Texas criminal courts. So his entire opinion is predicated upon a standard which is wholly and totally rejected for purposes of criminal cases in Texas.
So you object to Mr. Miller proffering an opinion as to whether or not he believed the defendant acted reasonably?
Yes, well, certainly as to reasonableness, that he applied in any context, reasonableness on any level, because he's applied the wrong standard. Secondarily, he's already conceded on my voir dire that he would be basing, or his opinion will be based on his opinion of reasonableness, which is not of any assistance to the jury, because the jury is fully capable, using the appropriate law that governs this case, to make a determination of an ordinary prudent person at the time of the situation. They are capable of doing that, Judge. All that Mr. Miller, because of his very commendable resume, all that allowing him to give his personal opinion does is it invites the jury to supplant their well-reasoned opinion, independent decision as jurors with his. That's not appropriate. Secondarily, Judge, his opinion that Amber Guyger believed is reasonable goes to his testifying as to her state of mind, which is not allowed. No expert is allowed to testify to the state of mind of the defendant at the time of the offense. Ms. Geiger has testified. The jury has been made aware of what her state of mind was. So I certainly disagree with both of those. Your Honor, I would object to, I think that just based on what I've captured from your statement already, that the rank speculation of ducking would not be permitted. I completely object to that. That is, first of all, that is wholly inconsistent with the testimony from the jury from the defense's case. Secondarily, it is based on Mr. Miller's belief of the path of the bullet in the body, but he never did attend the autopsy. He's got there's no proffered medical background. That would just be pure speculation. He's admitted that there's been hundreds of shootings he's been involved in where persons have ducked, haven't ducked, given a dynamic variety of situations. I think that is pure speculation. I would ask that that not be allowed. With respect to inattention blindness, as long as there is no testimony specific to Ms. Geiger, or no testimony that it happens in some sort of statistical number of cases, if it's just going to be testimony as far as generally this could be something that could be experienced, I think the court seems to be willing to allow that. I don't really know if I have any objection of that. I do think that that is also speculation, but nevertheless, if it's just going to be offered that it may be a possibility, I suppose that is going to have to be something we accept. So those are, I would certainly object to any kind of testimony that would ascribe some sort of degree of inattention that Ms. Geiger would have experienced in this particular case. Again, I think that only Ms. Geiger can say that, and she has. As far as shoot, no shoot decisions, I actually was going to argue based largely, I think the court also picked up on this. Mr. Miller is talking again anecdotally about his experience of shoot, no shoot, without any kind of a basis of any scientific studies which gauge it. other than to say that, you know, he's been to the range a lot. And yes, there may be information which suggests in a shooting situation, you know, the shoot decision or the no-shoot decision, but there is no information before me or before you that talks about probably the vast more decisions where officers don't fire at all. So that information, I think, is also without any kind of scientific or reliable basis, which means that it should not go in front of a jury, when all it does is just throws speculative possibilities in front of a jury without any kind of basis upon which the jury could actually use it in a productive way. So I object to anything other than perhaps just a general belief that inattentional blindness may occur and that the focus may be on the threat.
Yes.
First of all, with the Mr. Miller's articulation of a reasonableness standard, he is discussing the reasonable standard set down in Fourth Amendment jurisprudence in 1983 excessive force cases by the Supreme Court, and how the decision on whether a suspect's Fourth Amendment was violated, whether excessive force was used, is that of an objectively reasonable officer facing the exactly same set of quickly evolving, dynamic, tense circumstances and the decisions made when the trigger is pulled. And that hindsight is not 20/20 hindsight is not how you look at it. You look at it from the perspective of the officer and whether the officer was reasonable when the force was used. And that's what I've asked Mr. Miller to do, look at it from the perspective of Ms. Geiger in this case, based on all the discovery, the autopsies, the body cams, and the testimony that he's witnessed in court. To say that it's been rejected in Texas criminal case law, I don't know of a case that has specifically rejected it. I'm not aware of that. I understand we're looking at an ordinary and prudent person, but there's Mr. Miller can make that distinction, that how he looks at it, how he analyzes it, and apply it to the ordinary and prudent person standard, if you allow him to get into the reasonableness of his conclusions that he believes that is, you don't have to have a scientific experiment for every opinion that someone offers in the courtroom. He is qualified as an expert. This is the observe, orient, detect, act. That's something that is triggered in every tense, dynamic situation that an officer faces, and Mr. Miller can apply that knowledge that's applied widespread in police practices and procedures. The field of expertise that Mr. Miller has is legitimate. The subject matter of his testimony is within the scope of that field, and his expert testimony properly relies upon or utilizes principles involved in the field. He doesn't have to have every scientific study that's done to apply his 37 years of experience in addition to his training. And under 701, 702, 704, we proffer and pursuant to Nino v. State and the case law in Defendants Exhibit 93, we would proffer Mr. Miller for those opinions.
Mr. Miller, you do have a distinguished and glowing career, and I commend you for that. The court will allow you to testify as to the inattentional blindness and the principles of observe, orient, detect, and act. However, there will not be any testimony as to whether or not you believe the defendant's actions were reasonable, or whether or not the defendant believes that her actions were reasonable, nor will there be any testimony concerning the movement of the complainant. As you testified, it's a logical conclusion that one might believe that the complainant ducked and took cover. And inasmuch as it's simply a logical conclusion, if that's the conclusion a jury wishes to reach, I don't believe they need experts to tell them that. Well, I'm not going to allow any testimony from you or any other persons that the use of deadly force was reasonable. That will be for the finders of fact to determine. And I don't believe that it's appropriate that we use the reasonable police officer standard. But that being said, are we clear on what the area of his testimony may be?
Yes, Your Honor.
Okay.
Yeah, it's Judge, one matter of clarification again. Are you going to allow the testimony in a general sense?
Generally.
Okay. So
Not
no,
specific.
not specific to Ms. Geiger.
Correct.
And
Make your objections.
further object that the excluded testimony violates the compulsory process clause and the due process clause of the United States Constitution.
Overruled. Okay. Do you all need a break before we bring the jury? Okay, we'll bring them in at 10:15.
Okay, Barry Sorrells. No, yes, that's it. Barry Sorrells.
Perfect. Thank
sorry,
you very much.
we had this whole discussion about pronouncing names. Barry, you're joining us this morning to talk about the Amber Guyger trial. Talk to us about what we've just been hearing here with this whole discussion about whether or not Craig Miller can testify.
Okay, well, the prosecution is calling Mr. Miller as a expert witness as opposed to a fact witness. That is a category of witnesses that special rules apply to. Experts can have much more freedom to testify about things that they want to testify about, that comprises the basis of their opinion. They can support their opinion in the case based upon research and their specialized knowledge and their background and history. You cannot lead on cross-examination an expert like you can a fact witness. So they have much more opportunity to just testify to the jury without objection. So, and jurors, as a general rule, want to believe someone that's truly an expert. And so the law says that before you can call an expert witness, the opposing side, in this case the prosecution, is entitled to a hearing outside the presence of the jury to determine, number one, is this person truly an expert? Do they have specialized independent background and history that gives them specialized knowledge about what they're supposed to testify to? What's the basis, if they have that specialized knowledge and they're going to give an opinion, which Mr. Miller says he's going to, what is the basis of that opinion from a scientific point of view and your background, research, experience? I mean, why are you given this opinion? Is it based upon, scientific data and research and professional experience, or is it just basically an opinion that you're given that gives the appearance that it's scientific?
Kind of like pseudoscience.
Yeah, pseudoscience, and there's been a lot of that in the courts over the years, and it's really been the focus of attention in the last few years. And lastly, if you are an expert and if you do have a scientific basis for your testimony, is it going to assist the jury in helping them make a decision in this case, because we don't have that they don't have that specialized training, experience, and knowledge that an expert does. And so if all the qualifications are made, it makes sense that they can rely upon the expert's opinion about relevant issues in the case. And that's the last criteria. Is what you have to say relevant? Will it assist the trier of fact, or will it be confusing? And the judge, I love this term, the judge in this hearing outside the presence of the jury is called the gatekeeper.
Oh, okay.
Because the judge can say, no, I don't think your testimony is reliable. I don't think it's going to assist the trier of fact. I think it's confusing. I don't think you have the training or expertise to testify. Or, yeah, just the opposite. You meet all of those requirements, and I think your testimony and specialized knowledge and expertise would benefit the jury in this case. And then there's the third path, which is what Judge Kemp took, which is, okay, I've heard, your background experience, the opinions that the defense intends to offer. I'm going to let some of it in, but I'm going to keep a lot of it out, because some of it I think you're qualified to testify to, but other opinions on other issues, relevant issues related to this case, you're not. So she has limited his testimony.
Severely limited.
Severely limited.
Well, and what he wanted to testify to is that he believed her actions were reasonable based upon his knowledge and training and experience. He was going to say that she believed that she was confronted with an intruder coming at her, and in that split second made a decision to fire, and that he believed that was reasonable. He was also wanted to talk about this inattentional blindness, which is this concept that your mind focuses in on the perceived threat, whether in this case is you don't know where somebody's hands are, or the knife, the gun. But basically she's saying, I don't want any testimony about what you think Amber Guyger thought, or whether or not it was reasonable. You can testify generally. That's how I took it?
No, I think that's an accurate synopsis of the judge's opinion. She's basically said, the general concepts of what you have to offer, a condition that you've described, that police officers in high stress shooting events may experience, which is unintentional blindness, which means you have tunnel vision, you're focused on what you perceive to be the threat, and because of that, you're this hyper alertness to the exclusion of other things that normal people would be observing would cause you to react in a more defensive manner by shooting your weapon. Okay, if you want to talk about general concepts that you know from your training as a former police officer and your research and the data that you've examined, the concept of unintentional blindness, she's going to let him talk about that in general. But she's not going to let him say, which is what the defense called her to testify to, is that Amber Guyger experienced that, and that helps explain why in this situation she felt like her life was in jeopardy, and that Botham Jean was legitimately placing her in fear of death or imminent bodily injury, and she fired her weapon. Because you know why? That makes perfect sense if you think about it. There's only one person that knows what was going on in the mind of Amber Guyger, and that's Amber Guyger.
And we heard from Amber Guyger yesterday.
Yeah,
so.
And we did, and I think if I'm going to play the role of the prosecutor, and I don't mean to be critical of any lawyers in this case, because
But go ahead.
I'm not going to be.
Oh, okay.
The fact, if it was justified, I would not hesitate. But Robert Rogers, Toby Shook, Jason Hermas, the other lawyers involved in this case, they're all highly skillful, and I think that they're doing a good job. I would be critical if it was, if I really felt that it was justified, but I don't feel like it is, and I think Judge Kemp's done a good job presiding over this trial. She's obviously skillful and confidential, and for a trial to be of this importance to be broadcast to the nation, I'm glad that in Dallas, Texas, the world is seeing that we have capable and competent people that take on the task of trying these cases. So nothing I say is intended to be critical of lawyers on either side. But the biggest problem with this case for the defense is that you have to believe Amber Guyger's version of the facts with respect to self-defense for it to be a defense that's going to work. You know, Mr. Jean is not here. He can't tell the jury what happened from his perspective. So we only have the word of Amber Guyger. I mean, there's forensic evidence, and obviously there's been a battle about the position of the body and the forensics, the trajectory, and what that meant. And the defense is trying to make him more of a threat by putting him closer to the door, and the prosecution is wanting to rely upon the location of the body to show that he was, you know, almost 5 yards away, and that's inconsistent with his rapidly approaching her and being more of a threat. So the jury, when they go back, they're going to go, now she's testified that this man, this kid that works as an accountant at a big accounting firm with a college degree and no prior criminal history, and apparently he's, you know, sings in the choir at church, all of a sudden turns into a ferocious, I'm going to, individual that's going to give the armed police officer in uniform with a gun, she's going to think that it's realistic that he's going to kill her, in other words. So to believe that, you have to believe Amber Guyger. Well, she's not a disinterested witness. She has a lot riding on the on the outcome of this case. Now, she could be telling the absolute truth. I don't know. But I'm just saying a jury's going to go, well, wait a second, that's her word. She's got a lot to gain here. If we believe her word, then she walks out the door if we find her not guilty. So they're going to be saying, okay, let's set her testimony aside and look at everything else and what's consistent with her version of these facts. And so they're going to be going through the other evidence with a fine-tooth comb. So can you, I was a little wordy there, and it's a long-winded answer.
But we got plenty of time.
But yeah, I mean, that's her best defense in this case. You know, you know, it's a, you know. So they've decided to go with self-defense, which means, and I think on cross-examination when she was on the stand, the prosecutor said, did you intentionally intend to shoot and kill Botham Jean? And Amber Guyger testified she did. Well, that does a couple of things. Number one, it eliminates, in my opinion, Judge Kemp has the final say, and she may disagree with me, but it eliminates voluntary manslaughter and criminally negligent homicide, I think, because those are offenses that have to be...
Wait a minute, say that again. What eliminates those?
I think her saying that she intentionally...
Intended to kill him.
Intended to kill him eliminates the lesser included offenses of manslaughter and criminally negligent homicide. Wow. Because
was that a mistake? I know it stood out to me when I heard her say it.
You can't go halfway in on self-defense. You can't, you know, sort of have your cake and eat it too. Mm-hmm. If you really legitimately and reasonably believe that someone is about to use unlawful force against you and kill you or cause serious bodily injury, then, and if you kill that person in self-defense, then that's legally justified. So you have to, for self-defense to apply, you have to believe that your life was in danger. And so she said, yes, I believe that in essence, and that's why I killed this man. It wasn't through accident, mistake, or being risky in the discharge of her weapon, or that she should have known of a risk in firing her weapon.
Which would get you to reckless, which would be the manslaughter standard.
Exactly. You've been covering the courthouse much?
A little bit.
I know you have.
Yeah. So do you think we will not see lesser included offenses then?
Well, my opinion, and I've been keeping up with the trial, closely keeping up with it, I felt like beforehand, based upon what was out in the public domain, that the murder was the correct charge, and that the only way that lesser includeds could have come into evidence is if it had been raised by the evidence, and I don't think so far it has, that would justify a lesser included offense that has different mental states as an element of the offense, like reckless for manslaughter or criminally negligence for criminally negligent homicide. So I think it's going to be, murder's going to go to the jury. A charge on self-defense is going to go to the jury, and they're
Let the chips fall where they may.
And that's right. So, yeah.
That's it's funny that you say that, because the moment I heard her say that yesterday, I went, okay, because instead of saying my intent was to stop the threat, i.e. this person coming at me that she says was coming at her, you're right. It does make it. That's interesting. It'll be interesting to see if they do try to do lesser includeds, I guess. I mean,
yeah. Well, that.
Or if the judge allows it.
Well, that will be interesting to see, and if it's possible that the prosecution or the defense could argue for it. It's possible that the judge, if both sides wanted it in there, the judge could say, okay, both sides want it in there, even though it wasn't raised by the evidence, I'm going to put it in there because if both sides agree, there's no basis for an appeal. But I imagine Judge Kemp's going to continue to do what she's done so far, which is skillfully apply the facts to the law and making her rulings on motions and requests. So, at this point, my guess is it's going to be straight murder, and they're going to get charged on knowingly, intentionally causing the death of Botham Jean, and then it's going to be a charge on self-defense. But if you believe that the defendant was in reasonable fear of serious bodily injury or death and acted in self-defense and it was justified, then that's going to be a not guilty. So it's either going to be, in my opinion, this is predicting the future, it's either going to be a murder conviction or it's going to be not guilty because of self-defense.
So I've been kind of trying to monitor the Facebook comments. One person wanted to know, would you have defended Amber Guyger?
Absolutely.
And if so, what would have been your defense strategy?
Well, I think that based upon what I know from just the publicity beforehand and other things I had an opportunity to see, like related to the case that were out in the public domain, documents and stuff that were available to anyone's, and what I've seen in this trial, I think that Robert Rogers and Toby Shook, the defense that they've put on is pretty much the best defense possible. I'm sure they would say it's because that's what the facts of the case are, but I think the way that they're handling this case from a defense standpoint is competent, capable, and skillful, and it's really the best approach to defending this case.
And somebody else asked.
But can I add one thing?
Sure, no, go ahead. Again, we got plenty of time.
It goes back, the problem that Robert and Toby have is what every defense lawyer has in a self-defense case, and that is jurors, like I mentioned earlier, I don't want to be repetitive for our audience, are going to say, a lot of this, if we're going to believe self-defense, depends upon the testimony of the defendant, because there were only two people there at the most critical time during these events, and one of them can't come in the courtroom and testify. So that's why they're going to closely scrutinize all the other evidence to see if it makes sense. And I think the last time we were together, I said...
It was during pre-trials, right?
Yeah, I said the worst thing that could happen, and I'm sure Robert Rogers and Toby Shook's worst fear is that Amber Guyger be caught misrepresenting, lying, embellishing, that kind of thing, because the jury's going to take the position when they're analyzing her testimony is that if she does get caught in those circumstances, they're going to say people misrepresent for a reason, and that's because the truth hurts them. So the defense is doing great work. I'm proud of them and the prosecution and the judge. Like I said earlier, it's a showcase trial. It's making our criminal justice system in Dallas look good because of how capable and experienced all these players are in this trial. Yeah, it's much easier sitting here talking to you, Tanya, than it is in that being a lawyer in that courtroom. You've heard the term bleary-eyed trial lawyer. Well, all those lawyers at day 5 or 6 here, they're really digging deep to get the energy they need.
It's like a marathon.
Yeah, it's hard.
It's not a sprint.
No, and it's tough, and there's a lot going on. And it's hard to turn your brain off at night when you're in trial because your subconscious keeps strategizing and trying to work while you would prefer to be soundly sleeping. So anyway, yes, they're doing a good job. I would have represented Amber Guyger had I been asked. I was a Dallas Police Association contract attorney in the 80s when I practiced law at Burleson Payton Gibson, and I represented numerous police officers on police shootings. Amber Guyger, whether you like her or hate her, whether you're pro-law enforcement or anti-law enforcement, whether you think she's guilty of sin, Amber Guyger is entitled to a fair trial. And the best way that she can get one is with skillful lawyers. And yes, I have represented many people in law enforcement. I would have represented her. I'm happy that she selected such outstanding lawyers as Robert
they've
and
got great
Toby.
reputations. So another question, I'm trying to, these comments are rolling so fast, it's actually hard to get them down, but another person asks, when we get a verdict, can the judge overturn it? I guess more like set it aside, is I guess what the judicial term.
Legally, there could be situations where the judge could overturn a verdict, and she could not overturn a verdict of not guilty, but there are certain circumstances where a judge could set aside a conviction in a criminal case. It's rare, it can happen under exceptional circumstances. If Amber Guyger gets convicted, I imagine the defense will be filing a motion for a new trial, and there will be legal grounds as to why the verdict should be set aside. There could be hearings. I mean, for example, juror misconduct or other types of misconduct. But verdicts are set aside by the trial court judge. In rare circumstances, typically the verdict is maintained, and then any issues about being set aside are raised on direct appeal of the case to higher courts.
Okay. And one thing I noticed that Robert Rogers said right there at the end of that hearing, he said that he basically objected and saying that this violates the due process clause of the Constitution. Is that the kind of thing he's trying to put into the record for an appeal later on?
Well, one of the responsibilities of a trial attorney that is in trial and trying a case is to protect the record. And by that I mean to make proper legal objections when they're justified by something that develops in the courtroom. And so that because on appeal, the only matters that an appellate court can consider on appeal as a general rule are issues that were objected to at the trial. So he's protecting the record. He may be doing it to be cautious. He may be doing it because he thinks it's justified, but it's typical and really not something that anybody needs to be concerned about.
Okay, the judge is back.
Thank you. You all may be seated. Good morning, everybody. Thank you all for giving up your Saturday for us. Mr. Lapis, please call your next witness. All right, Your Honor. Ranger Armstrong has Please make yourself comfortable, sir.
Ranger Armstrong, the members of the jury have already met you. I'm not going to go through all your qualifications, but just in summary, you've worked with the Department of Public Safety. In addition to the academy, you've been with the Texas Highway Patrol, SWAT, and the Texas Rangers, correct?
That's correct.
And currently, are you assigned to a tactical unit?
Yes, I am.
And what unit is that?
That's the special response team.
And what do they do?
They do similar tasks as a SWAT team. The SWAT team for DPS is a full-time team, which that is their only job. The SRT that I'm a part of is a collateral duty team, which means I still do my primary ranger responsibilities of investigations. In addition to, when needed, I perform tactical tasks with the SRT.
And so, in line with your training and experience throughout the Department of Public Safety, and can you tell the jury generally about sensations that a person might experience when confronted with a quickly evolving, tense, dynamic confrontation with a suspect?
Sure. Some of the physical sensations that might be felt by somebody experiencing a scenario, as Mr. Rogers put, would be auditory exclusion, which basically means that you may not hear at the normal volume that you normally would because you're under stress. You may have vision narrowing or tunnel vision, which means you are only focusing on what is directly in front of you, not in your periphery. You may also experience short-term memory loss, which may be regained over time because your mind is prioritizing tasks at that moment in time. And the last one that you may experience is also a rapid heart rate, which may increase to a very elevated level due to the stress that you are experiencing mentally, physically, and psychologically.
I'll pass the witness.
Where's the witness, Judge?
Yes, sir.
Ranger Armstrong, I'm going to show you what's been marked for identification as State's Exhibits 321, 322, 323, and 324. Starting with 324, do you recognize that as being a still picture off of Officer Wynn's body-worn camera?
Yes, I do.
And that's going to be a fair and accurate depiction of the officers giving CPR to the complainant while they were in 1478.
Yes, that's correct.
And then 321 through 323, are those going to be fair and accurate depictions of the shorts being worn by Mr. Jean at the time he was shot after they had been received and photographed by the Dallas County Crime Lab?
Yes, sir, that's correct.
All right. Your Honor, I'm going to offer states 321 through 324.
No objection.
They're all admitted.
Ranger, Mr. Jean had no pockets in his shorts, correct?
That I cannot answer.
Let's see the pictures.
Sure.
Front view, sort of side and side view.
And you said no pockets?
Correct.
That's correct. It doesn't appear to be.
I pass the witness.
Nothing further, Judge.
May the ranger be excused?
I'll have him stick around, Judge.
Okay, thank you very much.
Yes, Your Honor.
Take the approach.
Yes.
So Barry, talk to us about what's going on here with Ranger Armstrong.
Well, Ranger Armstrong is also going to be limited in his opinions and he can only testify as to areas of expertise that he possesses based upon his being the lead investigator in this case. He can't speculate or testify to things that the evidence doesn't justify. For example, is what was going on in the mind of Amber Guyger. Again, the same thing with the expert that was on the stand before the break. You know, there's only one person that knows that, so it would be speculation on this ranger's part as to whether or not you know, what Amber Guyger's saying is true and accurate. And also the issue of, you know, he can't sit in the place of the jury and testify to something that only they can decide, like did she commit a crime or was her behavior justified. That's up to the jury, not him.
Yeah, the interesting thing, the most interesting thing about David Armstrong is what she has said the jury cannot hear. They had this long, lengthy hearing yesterday afternoon where basically she said he wanted to testify that Amber Guyger was reasonable, that it was not a crime.
Yeah. Well, I'm sure the defense loved that, and I'm sure they would love that the judge would have allowed him to or will allow him to testify to that. But that's not his decision. He's and I don't mean this in a derogatory sense, he's a foot soldier. His job is to investigate the case, figure out what the evidence is, and present that to the prosecution. His job is not to sit in judgment as a juror in the case. So that's the ultimate decision of the jury, and it's one that only they can make. And typically experts aren't allowed to stand in their shoes on the ultimate decision. It's not his job. And I think the judge is making the right call, not permitting him to do it.
Why do you think we've suddenly had this little delay here, though? I mean, this break, this sudden break. I mean, is it just are we just taking a mid-morning break? Is that what's going on?
You know, breaks at trial, that's a good question. I mean, it can be any number of things. Typically, it's an issue, the judge is taking a break because there's issues that can, if she gives the lawyers time to do some footwork and have some discussions, and then it ultimately would be a time saver as opposed to having a hearing with witnesses. So it can be an opportunity for the lawyers to, you know, do some more digging on some admissibility of evidence. It can be an issue related to witnesses unavailable or something that happened, or the judge needs to do some research. I mean, delays in trial are frustrating, particularly if you're a spectator, but it's routine and it's customary. Overall, I mean, the fact that this case started on Monday and here we are on Saturday, I mean, I think Judge Kemp, who it's her job, number one, to make sure that Amber Guyger and the prosecution get a fair trial. Number two, it's her responsibility to rule on objections and according to the law. And number three, it's her job to make sure that the jury receives the evidence in an atmosphere of peace and tranquility. And lastly, and informally, to move things along at an appropriate pace and not let the trial drag. So overall, I'd give her, you know, plus positive on doing her job right this week. And if, because of the credibility I think she's established in presiding over this trial, if she determines that we're going to take a break and everybody's going to go do what they say they need to do and it'll ultimately save time, then I'm convinced and believe that it's a reasonable break in the action. She's doing it for a good reason, because she wants this thing to move along. And the jury's sequestered. And that is, to say that that's an inconvenience in their personal lives is an understatement. And the role that they're playing is so critical to the determination of what's justice in this community. So I think she's being very attentive to the thoughts and feelings of the jurors and not wanting to waste a moment of their time.
So some other questions that are coming in from Facebook. as somebody was asking, well, why couldn't they do all this, these hearings like this before the trial, like in pre-trial hearings? I guess people are kind of, but this is the tedium of a trial, right?
Yeah, I mean, as a general rule, yes. It could be, some of this could be done prior to trial, but there's major inconveniences and expense involved in getting witnesses down there, having all the lawyers present, the defendant present, and the thing that the citizens don't understand is that this is one of a whole bunch of cases, and so it's more economical from a mechanical standpoint to do it all at once or immediately before trial. It's time consuming and it's expensive. And so if we're going to be trying the case, all the witnesses are going to be down there, they're going to be available, let's do it then. So it makes sense if you understand, the responsibilities of the court and how many cases she has in management of her docket. Overall, I would say this is the most efficient way to do it. But if you're watching the trial, it's like, hey, let's get this show on the road. But speed is not. It's efficiency and being expeditious is a concern, but the real concern is justice. And so it's one of those things that's routine in trials, and you have to be patient. You have to go into like a Zen mode of relaxing and just rolling with the flow. It helps, otherwise, your blood pressure is going to go up.
Okay, we got some more good questions. Would you have tried to plea this out before the trial?
Well, all lawyers, all defense lawyers want to engage in plea negotiations, and it's part of the defense lawyer's response. In most cases are resolved by plea bargain agreements, and that's for a lot of reasons. And plea bargaining makes perfect sense. Oftentimes it's a compromise, and it's based upon a totality of circumstances, the facts of the case, the law, the history of the defendant, the chances of what could happen at trial, what would a jury do. And so as a defense attorney, when you're representing someone charged with a crime, you negotiate, as a general rule, every case to get the very best offer from the prosecution on the table.
Do you think they would have offered that? It feels like this was the kind of case where the public would have wanted.
Yeah, well, that's exactly right, and that's where I was going. But back to the cases that are plea bargain. I mean, in negotiations, you get your best offer on the table, and then you let your client know, here's the evidence, here's the law, here's the offer, here's my recommendation on what you should do or not do, but it's your decision on what you want to do, and if you don't want to accept it, then great, let's get ready to go. And but in this case, which is the reason the world is watching this case, and it's being broadcast across the globe, is that you have issues involved in this case that are significant. You have the issue of white police officers shooting in an unarmed black man. You have excessive force issues possibly by a police officer. You have the legitimate issues of mistaking this for her apartment and tragic accident but not a crime. I mean, this has a lot of stuff. And my hunch is, and I don't know, is that sometimes and rarely the decision is made to this case needs to go to a jury and let them decide what the true facts are, and let them decide what should happen to Amber Guyger, let them decide what would be justice for Botham Jean. And that way, the right to trial by jury, although most of us don't, I do, I appreciate it. I always show up for jury duty. I never get selected, but I know a lot of people don't, but you should. I think it's even more important than the right to vote, because 12 people that will make the decision, the 12 people in this case that will make the decision, they took an oath to a true verdict render, and they're together, they're much smarter than the individuals. As a whole, they're much smarter. And it's been my experience of trying over 300 trials that they make the right decision based upon what's presented in court. So they don't have an interest in the outcome. They're supposedly, or they are fair and unbiased. They just want to make the right decision as to whether guilty or not guilty. And in a case like this, with all these dramatic cultural and societal and judicial issues, there's no better, nobody is a better decision maker than an American jury or the 12 people that are sitting in this case. So there probably wasn't plea bargain. It's too controversial. Let a jury decide. They're the best decision makers in this case anyway.
I just want to let folks know part of what's happening is the questions are rolling, the comments are rolling so fast on my screen that I'm trying to write questions down as you ask them. So if you don't ask it, just, ask it again and I will try to get Barry to answer it. Here's another one. How long do you anticipate this trial will last?
They're working Saturday, and the defense is calling experts, witnesses, to give opinions they feel like help support the defense of self-defense. It's impossible to predict these things. If I had to predict, I would say Wednesday. I think we'll, as far as presenting evidence, I think arguments, if I had to guess, and it's guesswork, the lawyer that will give final arguments on Wednesday. I think we'll have a verdict by Friday of this coming week. Guesswork.
So you think potentially that, assuming she's found guilty of something, that of murder or a lesser charge, of course, from what you said earlier, you don't think there'll be a lesser charge based on her testimony, that we could see punishment go into that following week. So we could go into a third week.
Yeah, if she gets convicted, there will be a separate punishment hearing to determine what the proper sentence should be, and that's going to be up to the jury. So there's two hearings. The first hearing in a criminal case is the determination of guilt or innocence, and if someone's found guilty, then a second hearing punishment to determine the proper sentence in a case. So I'm saying next week we'll have a verdict on guilt or innocence, and if she's convicted, the following week, like you described, would be a punishment hearing.
Official record. Okay. And then I guess you'll let you see it.
Sure.
Stick it on the file. Okay. Can I see you guys over here?
Okay, so while they're on sidebar, Barry, I've got a couple more. Some folks are asking, do you think that we'll hear from Amber again?
I think, I doubt it. Putting your client on the stand for a lot of reasons, I mean, that's a difficult thing to do. I know people think that direct examination is an easy part of the trial for a trial lawyer, but it's not. It's difficult. And and it also, if she gets back on the stand, it will subject her to additional cross-examination, and maybe the prosecution will make points they didn't make the first time around. So I'm sure the defense's first thought or impulse would be, I don't want to put her back up there because it subjects her to additional risk. But on the other hand, if something gets developed with these additional witnesses that the jury hears from since she's testified, and there's something that ties the hands of the defense and she has to get up there and respond or explain it, then, and it's critical to their defense, then they could recall her.
We've also got someone asking, why can't we see the jury? I can explain that. The judge, in trials, you never see the jury. In fact, whenever you, it's part of protecting their anonymity so that they can make a decision based upon the facts and evidence in court, and so they're not influenced in some way by outside forces. So whenever we cover a trial, we are if we have a camera in the court, we are never allowed to video the jury. In fact, the judge actually went so far in this case when we had that issue with whether or not that juror, no, it wasn't that. Oh, I know what it was. It was early in the first day of trial, when there was this issue with whether or not the DA had violated the gag order, when she questioned those jurors individually, she wouldn't even let us have sound on because she didn't even want to take the risk that their voices would be recognized. So that was just one of the questions.
It's interesting to be able to see the body language, facial expressions of the jurors, and I can understand why someone would be interested in seeing what they look like and seeing their faces when they're hearing the evidence. But that general interest, because of just kind of it'd be a kick to be able to see how they're doing over there, is trumped by these other issues that you just described that the judge is concerned with. I mean, practically there's no reason why the public needs to see on television the individual jurors. They don't need to be concerned with being, on television. They don't need to be concerned with potential safety issues that are being harassed, or so it just makes perfect sense. It's not. It's good. It's good television, but it doesn't make sense.
We understand that's
Yeah.
Those are the rules. I was just trying. That was a question that
Yeah, it's a good question.
that was asked by someone out
When
there.
I'm trying
so
a case, I love looking at the jury, but it's like tea leaf reading.
Okay, so here. Let me ask a couple more here. Somebody wanted to know, will we see the jury when the trial is over?
In high-profile cases, and I think most of our viewers have probably experienced the same thing or noticed the same thing, that typically there's 2 or 3 jurors that
Sometimes talk.
sometimes talk. So it could go either way. Sometimes they don't. Sometimes they don't talk to anybody. And sometimes there's 2 or 3 jurors that go public and explain what happened back in the jury room and talk about the case. They're free to do that. It's up to them, but so we'll see.
Someone else asked, why have we not seen the so when the day after the shooting, Amber Guyger gave an interview to the Texas Rangers. We've not seen that interview. I think it might have been part of the motion in limine. I'm not sure why, though. Do you have any sense of why we would not have seen that interview?
I don't.
Speculation? What would be your informed reasons for why?
Typically videotaped interviews, if someone's not in custody, then Miranda wouldn't apply, and it would be admissible.
This was an interview that she would have given, with her attorney and everything.
Before she was arrested?
Yes, it was the day after.
Yeah, so there must be compelling reasons why we haven't seen it. I'd have to know more, and I don't want to act like I know something I don't. I'd have to know more about it before I said why, because I don't know.
Someone was asking about where they could go to see Amber Guyger's testimony. You could go check out our YouTube page and look at day 5. She was the first witness up, so you'll be able to see it pretty easily. And she was on the stand for 3 hours. So somebody's reminding me how long it was.
Could I interrupt you?
No, go ahead. Keep going.
Yeah. So for in my history, I used to travel to New York to appear as a guest legal analyst on Court TV, the channel that covers trials coast to coast, and it was a great experience because I learned one thing, and I understand that the Court TV personnel are doing the feed and covering the trial, or someone affiliated with them, and they're very skillful at it. And from that experience, I came to believe that if skillfully done and if the requirements of the judge are met by the people doing the camera work and covering the trial, then it's really beneficial, I think, for America, Texas, Dallas, and every other community where an important trial is taking place, to be able to see what happens in the courtroom. I'm a big proponent of cameras in the courtroom just so that we can all see what makes the trial even more public. And so I tip my hat to Judge Kemp for letting this case be televised. She didn't have to do that. Federal court, they don't permit it. I practice in federal and state court, and forget about televised trials in the federal system. It's just, at this point, looks like it's never going to happen, but it's discretionary with each individual judge in the state system. I think it's great in a case like this, because of all the factors I mentioned earlier that make this such an important trial, is that we all be able to watch it, and now we can go on the internet, see pre-recorded or recorded stuff, and watch it, and I think we need more trials televised, is my opinion.
I think a lot of people really don't. Those of us that have been around a long time and are in trials and stuff, it's very different than what you see on Law and Order. It's not like a 45-minute episode where, everything's nice and tidy and wrapped up. Things are frequently a lot more messy than that.
Yeah, exactly. It's the real world. It's not a rehearsal. There hasn't been rehearsals to cut out, all the downtime and all the legal objections and the sidebar conferences and the things that need to take place outside the presence of the jury, like hearings and stuff. But that is real world. It's not produced to be shown in a 120-minute segment with commercials or things like that. So, if you don't like that, get real,
Okay, so let's go for a few more questions. These two were off of YouTube. I don't have YouTube up. It would be too much to try to monitor all of them, but one of our digital folks is. We were asked, if there's a guilty verdict, will it mean the death penalty? I know the answer to this, but I'm going to let you answer it. So.
Would you like to?
No,
I know the answer too, but you seem so excited about having the answer.
Well, it's not capital murder, but anyway, go ahead. Explain to folks why it would not result in the death penalty.
Well, this is not a death penalty case. That is every offense in the state of Texas and most states, has a range of punishment. And we have capital murder in Texas, and that means if the jury finds you guilty of capital murder, and if the jury in essence, that punishment finds that you committed the murder intentionally, that you're a continuing threat to the world, and that there's no mitigating factor that would justify you given a life sentence, then you get the death penalty. In this case, the range of punishment is 5 to 99 or life, or anything in between. And in that's a first-degree felony, one step down beneath capital murder. But one thing that's unusual about a murder conviction in Texas, in most offenses, felony offenses, if you've never before been convicted of a felony in this state or any other state, and you swear to that prior to trial, then that makes you eligible for probation. And if the judge returns a sentence of 10 years or less and recommends probation, then you can get probation. In a murder case, if Amber Guyger is convicted of murder, the legislature has ruled that probation from a jury is not a possibility. So if she's convicted of murder, the minimum punishment she could get would be 5 years in prison, and anything between that and up to 99 years or life. So if convicted of murder, it's not a question of is she going to be incarcerated. The decision will be for the jury to decide how long.
There's another one. Will this set any precedent for future cases when it comes to use of force or stand your ground laws?
Well, that's a good question. Stand your ground laws, and that's a political legislative decision, but I think the best way to measure the future of any criminal case is the facts of that particular case and the law that applies to that case. Each case stands on its own merits.
Oh, okay. So we're still, the judge is back in the courtroom, but we're waiting to see what, presumably we're going to hear more testimony. You think we're going to have more hearings?
I don't know.
Maybe we had David Armstrong, Craig Miller. Maybe they're going to put Craig Miller on the stand to testify on these women.
Yeah, it could be another expert, or it could be one of the ones that we heard outside the presence of the jury. Jury's coming back. My guess it'll be these expert witnesses that she limited their testimony, and they're about to be called by the defense.
Okay.
All right, you may be seated. Ladies and gentlemen of the jury, you've heard all the testimony that you're going to hear today. I'm going to ask that you be back here on Monday at 9:30 and we'll resume court at that time. I'm going to give you the same admonition. I think you all probably could repeat it with me. I'm not sure whether there'll be media coverage or not, and you should not be accessible to it, but if perchance, don't read it, watch it, or listen to it, or don't allow anybody else to talk to you about it, okay? I'll see you all Monday morning at 9:30.
All rise.
You all may be seated. Let's have a good evening. Well, I'd like to talk to your attorneys right quick. And then I guess the rest of you can retire to your homes off the record, Ms. T.
Okay, so it looks like she's calling the attorneys. I don't know if they're going to go into her chambers, but thoughts on what's happening here? This is kind of a surprise.
Yeah, it's not atypical. If I had, for these type of breaks or unexpected adjournments to occur, if I had to guess, and of course I'm not there and I don't know, is that something was presented to her on the issue of law with respect to her ruling on the content and admissibility of the experts that she heard outside the presence of the jury, that has caused her to say, hey, look, I've been shown something new, and I want to be cautious. I don't want to limit testimony if it shouldn't be heard by the jury, and I don't want to let the jury hear things they shouldn't. This in large part is a decision based upon legal precedent. She may have been presented something new. She has appellate lawyers that work on her staff and is helping her with this case. It may be that she wants to do some additional research, make a different ruling, modify her rulings on previously on these expert witnesses, or stick with what she's already said.
Do you think that's what it's about? It's not.
That's a guess, but that's what I bet it's about these experts and the admissibility of their testimony and her making the right decision, with the most important concern of hers is a fair trial for both sides. But on the other hand, any good judge does not want a case to have to be tried again, and she wants to make sure that if she can and it's reasonable, she wants to prevent any rulings that would be considered error in the appellate record and could affect the case being set aside in the future. So that's probably what it's about.
Dotting the I's, crossing the T's kind of
That's
thing.
what this is, probably.
So, because it would have to be something.
Did they break for the weekend?
She sent the jury home, and
Right.
then she called. She said she wanted to speak to the attorney. So what
Okay.
I'm not clear on is, are we going to have some more hearings?
Well,
She
she
just-
excused the jury. We're not going to have more testimony in front of the
Well,
jury.
right, but I mean-
But I think you're right. We don't know what's going to happen with the lawyers. They may have more work to do today, but I don't know if she wants to hear from witnesses again, hears legal argument, or she's going to excuse them. We'll just have to wait and see.
I mean, because she was pretty adamant that we were going to go till 4. So this is
Yeah.
definitely kind of a, okay, what's
Yeah.
going on here?
Yeah. Well, something happened that caused her to think a delay would be reasonable and in the long run beneficial.
Well, one of the things that someone's asking, and we've had a couple people wondering, like, is there some possibility there could be a sudden plea deal here?
Well, in the world of 10,000 things, anything's possible, and it's not, it wouldn't be unusual for a case to be negotiated a plea agreement. I've done it. Every trial lawyer's done it in the middle of trial. If both sides felt like it made sense based upon the state of the evidence and all the other stuff included in or considered in these type things. For the reasons that we talked about earlier, the jury of citizens with no interest in the outcome, open-minded as far as the evidence in the case and what the verdict's going to be, and hasn't been influenced by publicity and qualified to serve on this jury. I think if I had to guess, my guess is this case is going to go all the way to a verdict and should.
Yeah, for some reason it doesn't feel like this is a
Yeah, so
plea
I would
deal in the
doubt it.
making.
Yeah,
This
I
feels
would-
like more like what
Yeah.
you're talking about.
Yeah.
I mean,
I haven't seen, you can kind of get a sense that everybody's sort of thinking about that as a possibility, and that generally shows up, in the way lawyers act and judges act and stuff like that. I haven't seen that. It looks like everybody's exerting their best efforts and putting as much energy as they should be to try this case to a verdict.
we saw Amber Guyger just leave the courtroom. Does that make you feel like we're done for the day? Or, I mean, I guess she could.
Well, I don't know where she's going. If she's going home, we're probably done for the day. If she's taking a break and getting a drink of water, we may be coming back. So we'll see.
And then somebody's also asked, we've had several people ask, well, what if he had shot and killed her? In other words, if he had been armed and he had shot and killed her, thinking she was the intruder.
Yeah. Well, we'd probably be, flip the script. We'd probably be having, or might be having, a similar trial. Maybe not. It would depend upon the details, facts, and circumstances of that situation. But it's possible that he could have been charged and we've been in the same situation.
We've got Rebecca Lopez on. Oh, we don't have Rebecca. You want to get Rebecca? Okay. So she might be able to help us kind of get a feel for what's going on outside that courtroom since she's actually there. We've had several people ask again about this issue of lesser charges. And you've kind of given an explanation for why you don't think we'll have lesser includeds now.
Do you want me to
walk
talk
us,
about that?
Because folks they've asked it again.
Okay, well, I understand why everybody keeps asking about it. The main problem, and I'm going to give it my best shot, even though, do this for a living, there's these statutes are word salads, and legalese, and unless you live in this world, I'm not good at whatever our viewers do, whatever their job is. Believe me, I couldn't do it, I'm sure, and it's hard for you to know how to be a lawyer by watching this show, but so I'll try and be as concise as I can. There's two.
Hey, Rebecca.
I'm here.
Hey, so is your understanding, are we completely wrapped up for the day, or are they going to have any more hearings this afternoon?
It's a little unclear. We saw Amber Guyger go into that little side room where they keep the defendant and some, where the attorneys meet when you first go into the courtroom. Botham Jean's family is all still standing around outside the courtroom. No one's leaving. So it could be that they might have a couple of other hearings outside the presence of the jury. Obviously, they had the hearing with Craig Miller, and then David Armstrong was the only one to testify in very limited testimony before the jury. So I believe that they want to call some more witnesses, but for whatever reason at this point, no one else is being called to the stand today.
What's your sense of why we suddenly broke, though? I mean, it felt very sudden.
It does feel very sudden because, Craig Miller was prepared to go on the stand before the jury and talk about the same thing that Armstrong talked about, and that was the tunnel vision. That's the only thing that she was going to allow him to talk about. So I'm kind of surprised that they didn't at least hear from Craig Miller, the former Dallas deputy chief, that they didn't get any kind of any testimony before the jurors today, and that was it. Everyone was as surprised as you guys are, because this jury is sequestered, and part of what they want to do is move this trial along so that they don't have to keep the jury sequestered for so long. And so it feels like, just a couple of things and then you leave for the day is a little bizarre.
Well, Barry thought that maybe, this is speculation, but that maybe something had been brought to the judge and she had to consider some elements of the law about things that she had excluded. Is that maybe? You think that's what's going on?
Yeah, it may be that she was presented with additional case law that would make her want to look more closely at some of the legal decisions that she's made with respect to these experts' testimony. I mean, that's typically what would be happening here, is that she wants her clerks to more closely scrutinize some cases that she's been presented to make sure that her rulings are what they should be, and she's not making error at the trial, because she doesn't want some other judge to have to, or she doesn't want in the future, if this case gets reversed on appeal, to have this case tried again. So she's doing what all good judges do. She's being careful that if that's what's happened, that she's making the right decision. And this is if that's what's going on, this is what she should be doing.
By the way, one of our digital producers is making it clear that the judge said that she said everybody could retire for the day. So it's not just the jury. So it appears that proceedings are really completely over for the day.
Hey, you guys, I'm back. Real quickly, I apologize. I'm going to just step in for just a second. I was just, the Botham Shem family has left. They're leaving. And I spoke with one of the attorneys that's close to the family, and he says he believes that the defense's case is over, and they decided probably not to rest today because then the judge has to obviously prepare the charges that are going to be presented to the jury, and you can't deliberate on a Sunday. You can't have court on Sunday. So I suspect that Monday morning, the defense will rest its case, and the charges will go to the jury, and the judge will read the jury charge, and we'll have closing arguments. Because we were supposed to go until 4 o'clock today. There's no reason why all of a sudden it's over. And again, they limited so much of what the defense was trying to get in on what her frame of mind was, where do you believe that the body was, all of that kind of stuff that sometimes judges do allow in. In this case, they did not allow some of that type of testimony. So some of the Botham Jean attorneys, the family's attorneys, feel like the defense is done.
Do you think that's likely, Barry?
That makes perfect sense. And I'm going to take the position that that's probably what's happening. So if the defense is not happy now with the testimony that their experts are limited to, they've made the decision it's probably not worth putting him on the stand and subjecting them to cross-examination by the prosecution. And so if they can't get in the meat of the coconut on the points they wanted to make, then let's don't put them on the stand and let the prosecution make some points. And so they've probably told the judge that they intend to rest. Now, going back to her management of the case, it makes perfect sense at this point that she would take a break, and I'll tell you why. To serve as a juror, you're the exclusive judges of the facts that you hear from the witness stand as to what's to be believed, what witnesses are to be believed, what you hear. You judge the credibility of the witnesses. What the true facts are, that's your decision. But you don't, the facts get applied to the law, and we don't expect jurors to be lawyers. And so the court, the judge, at the end of the case, gives the jury, before they go out to deliberate, all the law that they need to know that under the facts and circumstances apply to this particular case. The judge reads, it's called the court's charge, which is basically, okay, jurors, you're the judges of the facts. I'm the judge that tells you what the appropriate law is that applies to this case, and I'm going to read it to you. You're going to be able to, and it's called the court's charge. You take it back to the jury room, and use this as a guide, a legal guide, to measure your verdict in the decisions that you make with respect to the facts. It's complicated determining what the proper charge should be. There's a lot of possibilities on what goes in that charge. Both sides are going to have proposed charges that they want in there that they feel like helps determine, helps the jury understand the facts better from their point of view. It's a tug of war as to what goes in and what stays out, and both sides, we can agree on some things, the defense and the prosecution, but things we don't disagree on. The judge is thinking, and it's time consuming. So my guess is the judge thinks it would be more thoughtful for the jury to not have to be sitting in the jury room while the lawyers make proposed charges that they want in the charge, and she hears and considers their request. She makes a decision, and she may have to do some legal research. This all has to be typed up and prepared. It's typically 10 to 15 single space, depending on the case, pages long, and it's time consuming. So she, I think, if this is what's happening, and it sounds like it is, she's being thoughtful, saying, go back to your hotel, relax, enjoy, watch TV. We're not going to bring you back Monday, then do this work. So yeah, it probably means that the defense is going to rest on Monday. The prosecution could present rebuttal witnesses, or maybe not. They could rest also. If both sides rest and close at the guilt or innocence stage of this trial, which is where we are, then it's time for the judge to read the law to the jury. And then after she does that, she tells them, go back to the jury room, select a 4-person to help you in your deliberations, take this charge with you, and basically, she won't say it, but good luck. Our thoughts and prayers are with you.
Hey, you guys, it's Rebecca, real quickly. So it looks like, I'm sorry, I'm going to jump in here real quickly because I've learned a little bit more new information. It appears that they might have had one or two other witnesses, the defense, and they're actually out-of-state witnesses, but they are witnesses that were supposed to testify about Amber Guyger's psychological state, which already the judge has said, you can't go there. So it just appears that they've run out of witnesses, and if they flew in witnesses and the judge is not going to allow them to testify, that I do believe that the defense doesn't have anyone else to call.
Wow. If that's the case, if the defense is going to rest, and we're going to see that on Monday, does this indicate that things are going badly for them?
Nobody knows. I think that I don't know what they're thinking, either side, prosecution, defense. I mean, I have my opinions, but to say that they think things are going badly, I would never, I have no idea whether they think that or they think that they're ahead. I do know this, is that the decisions that they're making, they feel like are in the best interest of their client, and they feel like every decision that they make, and they're well prepared in this case, and experienced and skillful, like I've mentioned earlier, every decision they make it thinking that it's going to increase the chances of a favorable verdict for their client, in this case a not guilty for Amber Guyger. So they're working.
And also, Tanya, what's interesting is on the defense team is one of the top appellate lawyers in this area. And so I would imagine that they are also looking at this point, appeals. So much of the testimony that has been excluded is sometimes allowed by other judges. Are they looking at that now and saying, well, depending, who knows what the jury's going to do if they find that there was reasonable doubt that Amber Guyger acted intentionally and murdered Botham Shem Jean. If they feel like there's reasonable doubt, obviously they have to find her not guilty, or if they feel like this was all intentional, well, then that's all up to the jury. But if they find Amber Guyger guilty, they've got a strong appellate lawyer on the defense team that is probably already looking at some of these issues that the judge has and some of the things that the judges has excluded in this trial.
Do you think that the judge's decisions, Barry, were reasonable?
You know, based upon, and I'm really surprised that I feel this way. I'm not just mooching up to the judge. I mean, usually I can find something to criticize, but based upon what I heard from the witness stand and the issues that I know exist in this case, I thought she exercised good judgment in her rulings, and they made sense to me. I mean, experts are called because of their specialized knowledge. What they have to say is relevant to issues in the case, and based upon science and research and data that justifies their calling themselves an expert, and it'll assist the trier of fact. But that doesn't give an expert the right to trespass on the responsibilities of the jury, which is be the judge of the facts, the credibility of the witnesses, and make a decision as to what the proper verdict should be. That's their job, not an expert's. So yeah, I thought she did a good job. I'd be surprised if she changed, well, if they're resting, you know, that's not an issue anymore.
Well, if they're resting, this probably goes to the jury Tuesday, right? Monday, maybe Monday.
Maybe, yeah.
Yeah, Jason Hermes has also just left. I saw him leave just a little while ago. So yeah, they're
I'll tell you
definitely not
something
going to be any
else.
other hearings.
Are we on?
Go ahead.
I'm happy. This is sort of personal stuff for trial lawyer talk, but I'm happy for the lawyers on both sides in this case that they get to take a break and get a Saturday afternoon and Sunday off, because they've been working really hard.
Well, and you kind of come back at it fresh on Monday then.
Yeah, and I'm sure you always need more time. That's the biggest problem when you're in trial, before and after. You always need more time because there's always things that come up that you don't foresee. So number one, they like the additional time to further prepare, and number two, hopefully they'll be able to rest up a little bit.
And someone has asked, can the state recall Amber Guyger?
You know, they could technically recall her since she's already testified, and the judge would have to permit it. It would be like recross examination, and the best way to get the judge to permit it, her being called back to the stand, would be if there was some development since she testified and since they had an opportunity to cross-examine her that would justify giving them additional time and different subject matter to cross-examine her based upon evidence that was presented after she got off the stand. It's possible.
And in your mind, what are the key things that this jury will have to consider, Barry? Walk us through that legal decision making.
Well, the issue of did she intentionally kill the deceased, Botham Jean in this case, she's admitted that she did. So the question for the jury becomes, was it justified based upon self-defense? Did she feel like her life was in danger and that he was a threat that she could reasonably believe intended to murder or cause serious bodily injury of her when she mistakenly went into his apartment? And reasonable is a key word. If the jury finds that she acted in self-defense, they'll acquit her. They're going to, so if they don't think that it was reasonable for her to believe, or she's not being honest about that, or that there were other factors that would not justify her relying upon self-defense, and she acted unreasonably, and they didn't really believe that he was a threat of death or imminent bodily injury, and it was immediate, then it's going to be difficult for them. So this is a case perfect for a jury.
It is. Hey, Rebecca, thank you so much for calling in, and I hope you have a good rest of your Saturday. So.
Yeah. There's still a lot of people milling around here. You know, I was just going to say real quickly that some of the witnesses, that the security here is really, really tight still at the courthouse. A lot of security surrounding this case. I know that at least one of the witnesses received death threats almost as soon as they got off the witness stand, and so I've seen DVD criminal intelligence, so there was a lot of people called up to this courthouse today, and so that makes me even more resolved in my thinking that that this case is done for the defense, because there's a lot of people, a lot of DPD officers, a lot of extra personnel up here for there have only been one or two witnesses that were expected. So I think the defense is just probably done. So just wanted to say that.
Do we have any idea who received death threats?
I'm not gonna say, only because there is a gag order, and they're not really supposed to be talking really to the media. They inadvertently sort of mentioned it, so. But.
Okay. All right. Well, thank you so much, Rebecca. I appreciate you calling in.
Okay. All right.
Just a couple more questions from Facebook. Some folks continue to ask about this issue of lesser charges. So Amber Guyger testified that she intended to shoot to kill Botham Jean. And what I understood you earlier to say is that you believe that the charge that will go to the jury is murder and no lesser included, like manslaughter or criminally negligent homicide. Why do you think that?
Well, can I have 45 to 60 seconds to give you the answer?
You can have 5 minutes if you need to.
I'm not going to do that to our audience. But if you go way back, like to English, the laws of England, that in large part we've adopted as a basis of our criminal justice system, to commit a crime, there's two things in general that must be present. And they're Latin terms that you never hear except in law school. Actus reus and mens rea. Mens rea is the state of mind. It's called a culpable mental state in English, and it's an element of every criminal case. And there's different culpable mental states. And then actus reus, so you have to have the state of mind to commit a certain crime. And actus reus is you have to do some act in furtherance of that crime or commit the action that causes you to be charged with the crime. Mens rea, coupled mental state. And it's so in murder, it's that on September 6th, 2018, Amber Guyger knowingly and intentionally caused the death of Botham Jean. Knowingly, intentionally. That's the mens rea that's required to be convicted of murder, and the state has to prove it beyond a reasonable doubt. Knowingly, intentionally means that was you did something with the specific intent to make sure whatever you decided to do was accomplished. So if Amber Guyger says, I intentionally killed Botham Jean, that means that when she fired her gun, she intended to end that man's life. So there's been talk throughout this trial of of lesser included offenses of murder, and that would be manslaughter and criminally negligent homicide. They're like murder's 5 to 99, a first-degree felony. Manslaughter is a second-degree felony with a range of punishment from 2 up to 20 years, and unlike murder, you can't get probation if you get convicted of that. Manslaughter, if you're eligible, you've never been convicted of felony for, you could get probation. Well, the culpable mental state for manslaughter is that you recklessly cause the death. That's a couple of clicks lower than knowingly and intentionally. Recklessly, of course, as most things are, is defined in the law. And it's a mumbo-jumbo legal sounding definition, and I'll try and simplify it. Basically, you are consciously aware of a known risk, and you intentionally disregard that risk and do some act that's reckless. I mean, for example, if my cell phone was a gun, and I'm sitting here in this studio, and I just decide I want to fire my gun, and I shoot through the wall, and it kills somebody on the other side, God forbid, that never happened. Okay, I don't say something stupid, but I mean, I should know that if I fire a gun, not knowing what's on the other side of a wall, and it kills somebody, I mean, that's reckless. I should have been aware of the risk, and I disregarded it, and because of that, someone lost their life. So if you're reckless, that's a second-degree felony, because reckless is a less of a, it's a lesser state of mind as far as the law is concerned. It shouldn't be punished as severely as knowingly, intentionally. So in this case, she didn't fire her gun recklessly. She says under oath in front of the jury that she fired her gun because she intended to kill somebody. That's not reckless, that's intentional. The other lesser included offense is criminally negligent homicide. And I think that is either a state jail felony or a third-degree felony. I always look these things up.
I think it's state jail.
State jail. I mean, that's just the first offense after a misdemeanor. It has a range of punishment of 6 months up to 2 years incarceration. Of course, if you're eligible for probation, you could get probation. And so criminally negligent homicide, the mens rea, or the culpable mental state, it's not intentional and it's not reckless, it's criminally negligent. And that's defined in the law. And the difference between criminal negligence and recklessness, you have to be consciously aware of a risk and disregard it. In criminal negligence, you should have been aware of a risk. You may not have been, but you should have been. And had you been, then the act you took wouldn't have happened. Like if this is my cell phone's a gun, and I decide I'm going to start racking the slide just to play with my gun, and the gun goes off and kills somebody, and I didn't, reckless, it's a question of whether or not I should have been aware of the risk of playing with a gun, but that's a better example than shooting through the wall. If I wasn't, I should have been, and that would be criminally negligence.
Okay, I'm going to ask one more question and then I'll wrap this up. This comes from a police officer who says, police are trained that you don't shoot to kill, you shoot to stop the threat. Do you think that she intentionally said kill to get the lesser included thrown out, knowing that a murder conviction is unlikely?
Well, I think...
I mean, certainly it sounds like an opinion on his part.
Yeah, well, I understand that there's a statement in the form of a question, and it'd be guesswork on my part to say yes or no.
That would sure seem like rolling the dice.
Yeah, I mean, I think under the totality of the circumstances, and even before the trial, and I think it's been confirmed by what I've seen come from the witness stand at the trial, is that reckless or criminally negligence is really not an issue here. And so you say kill versus stop the threat. Okay, I mean, I think that's slicing it pretty thin. I mean, the best way to, if you think somebody's trying to kill you, the best way to stop the threat is to kill them first. So, okay, we can argue about that, but okay, I'll just say, okay, different semantics. So I think the defense has put on a defense that they feel like under all the facts and circumstances make the most sense. And they're going with murder. And I think that may be better than riding 3 horses and trying to play games on lessers and stuff like that. They're going for a not guilty, and I'm sure that they feel like that's the best strategy.
Okay. Well, we're going to wrap it up for the day. Court started this morning at 9, and it was a bit of a shocker that we ended just after 11 o'clock. There were a couple of hearings. The judge strictly limited testimony, and what we think at this point is that it looks like the defense is going to rest, and they're probably working on the language of the charges that will go to the jury, and so this could be in the hands of, speculation here, hands of the jury maybe on Monday. So we'll be back to see what happens on Monday. Thank you so much for joining us.